My name is Mohamed Warsame. Welcome.
Karibu.
A very good morning, my Lord Justice Nduma Nderi. I am the Attorney General, and I'm on this panel by virtue of my office.
Thank you very much.
Your Honor, my name is Olive Mugenda, Commissioner representing the public and chairing these interviews. We also have the JSC Secretary and Chief Registrar of the Judiciary, Honorable Anna Madu, with us, and you could just kindly show you. We also have Honorable Wilfreda Mokaya, the Registrar JSC, right there at the corner.
Thank you very much.
A few housekeeping issues, Your Honor. Please feel free to ask any commissioner to repeat a question if it's not clear. Seek clarification. I'm also asking my fellow commissioners to also be precise in their questions and also keep to the time we have agreed. After 2 hours, Your Honor, we are going to take a short break, and Madam Anne will lead you to a place where you can have that break. So we will now start the interview, Honorable Judge, and I'll put the first question to you. Honorable Judge, tell us why you are the best qualified candidate to be our next CJ. Therefore, tell us your personal and professional journey briefly, and any other information you want to tell us to demonstrate that you are the best qualified candidate for this job. Thank you.
Thank you very much, Madam Commissioner. I was born and raised in Embu County, Runyenje Sub-County, where I grew up and I attended my primary school education. I was born of a mother who was a teacher and a father who was a headmaster, and I attended school from nursery school to standard 7 in the school where my mother was a teacher and my father was a headmaster. So the values which went to later guide my philosophy in life were inculcated there at very early stages by my parents, who were very committed Catholic Christians, and for all times I knew leaders in the church. And so they taught me values of honesty, caring about others, especially the neighbors, being kind to others, doing unto others as you'd wish to be done to you. And therefore, that was my anchor and my true north. I completed my school in my primary school there in Kiambua Primary School, which was, my home was just a few meters away from the school, and it still is. I went to Kangaro High School for my O levels. It was a provincial school, and that was my first encounter with Kenyans from different parts of Kenya, mainly from the larger eastern province, Machakos, Kitui, Moyale, Marsabit, Embu, Meru. That was the setup of a secondary school that time, and therefore had that exposure to other Kenyans. And I started my journey as a true Kenyan and a patriot that way. I enjoyed Nairobi School for my A levels, 1981, which was a national school. And my perspective of Kenya broadened when I met Kenyans now from every part of the country. When I met Kenyans now from every part of the country. And that is when I discovered my very easy way of dealing with everyone and literally every issue, and being very friendly and amiable with ease from people, Kenyans from all parts of. Indeed, my first friendships there, which persist to date, were mainly from Nyanza province. I completed my A-levels in 1982, and unfortunately, there was the attempted coup that year. And we had to wait for a good 2 years to join the university in September 1984. This, Madam Chair, is very important in the context of today, where we have so many anxious parents and children who have had to forgo school now for many months due to the COVID pandemic. My message to them is there is hope. It has happened before. We waited for 2 good years because of that nasty experience to join university. And therefore we became the first Kenyans, young men, to join the National Youth Service as we awaited to join the university. It was useful training, just like happens to policemen and the military, for discipline purposes. And I enjoyed the experience for the months we were there. And in September 84, we joined the university. Early 1985, it did not take long before we had one of the so-called Mwandawiro riots. I think they are so infamous in the manner in which they were suppressed by the armed forces, because so many of us were injured. Even I think we lost a few students in that riot. The students were in full military uniform from the National Youth Service in participating in that riot. It was nasty. And we found ourselves at home for almost another 8 months, reporting to the chiefs and with directions that no one should remain in Nairobi and we should all take our uniform to the chiefs in the village. And that is what happened. I was reporting daily, every morning, to go and just sit at the chief's camp until we were recalled back at the university. So cumulatively, that group lost about 3 years of learning. We were weary, exhausted. In 1986, it was a very profound year for me because I lost my mother in a terrible road accident. She was my anchor. And no sooner had I come back from saying bye-bye to her, I was confronted by a rainbow of students who demanded that I was going to be their chairman. And they were led mainly by a rainbow of Kenyans, mainly led from Nyanza province. From there, I started a journey which I had never envisaged. I was elected chairman of SONU. I campaigned on a platform of peace with a difference, because the students were weary and they told me, we want to go home. We want to start our careers. We want to leave the university. Unfortunately for me, we had fresh students also who had never experienced a riot. And they really wanted to test action, as it was called those days. And so I faced very fierce opposition, and I had a very worthy opponent but I won that election with a big majority. I was to face the first election petition in the history of Nairobi University. My election was challenged. A petition panel was constituted by the council. And I remember, and if I recall well, it was chaired by the retired Supreme Court Judge, Jack Tonojuan. I was successful in that petition, and I continued with my leadership. And I introduced many welfare initiatives, and I was able to see my year through up to the time I went to the Kenya School of Law. And some of those initiatives were hilarious, including the double dialogue menu. For those of you who don't know what dialogue is, it's chapati. And so I went to the Kenya School of Law. And that was a chapter in my life which again shaped my future, my career, which I embarked on as soon as I left, as soon as I joined School of Law. I was a pupil at the firm of Vora and Gitao Advocate. I was in very good hands of Muhindra Singh Vora, the advocate and the founder of Sarova Hotels. And in him I learned great qualities of servant leadership, which I espouse to date. He walked me in that year like his own child through paces of career nurturing. I was also in the same firm with Wahiga wa Maura, who was an associate there, a very staunch Christian and advocate of repute in the country, father to the citizen anchor. And in their hands, I started my career as a young advocate quite well. I joined the firm as soon as I was admitted. I joined the firm of Kioko and Company, advocates a use building, where I started a very robust practice in civil and criminal litigation. It was a very busy firm, and Mr. Kioko was completely hands-off. He left all the work to me and Mr. Okubo and the other associates assistants who were there. So I was admitted into the bar in the morning, and the same afternoon, I was to conduct a serious commercial dispute before Justice Shields. That's how I started my career. And so my courage, my practice from day one was very well anchored. Kioko is today a judge of the African Court of Peoples and Human Rights at Arusha. And after exactly 1 year, one morning, Mr. Kioko came to the office and told me, Matthew, I have been appointed as the head of legal by the African Union, AU, and I'm leaving in a very short time. I want you to talk to all the clients you've been serving, and he said the same to Akubo and others, and I will allow you to, if the clients so wish, to take over all that work because I'm leaving. And that is how I found myself very quickly into my own practice at a very tender age. That's how it happened. And I cut my teeth, mainly doing very many cases in Machakos, Kitui, where a lot of work was, and many parts of Kenya, because it was a busy practice which I took over with my colleagues. And so I was very well angered in litigation at a very young age. And soon my clients pushed me in a direction which led me to defending the leading lights in the second liberation of Kenya. Because we had forged very close relationship with Kadango, George Anyona, Professor Oyugi, Godho Karaoke, who I came to defend for a whole 1 year in the corridors of this building, largely on pro bono basis. In that moment when I encountered our Chief Justice, Justice Mutunga, who sat with me for minutes of that council, Muturi Kegano, Charles Nyachai, with whom we mounted a very formidable defense. It was a case of Kenya for Kenya. Again, I experienced, in that moment, I experienced Mutunga found a lot of time to sit with me and to guide me in that process. Senior as he was, I believe, with the Ford Foundation then, which also played a key role in supporting that process, which we embarked on for almost 1 year. Young as I was, at 28 years, I was given key roles in that, including the conduct of the trial within trial, including making an application for recusal of the team from the DPP's office. After it came to our attention that they were complicit in the extraction of the confessions in the Nyayo chambers. We also made an application for an inspection in loco at Nyayo House. And that immediately overnight led to the gazettement of Nyayo House as a security zone, because there was vehement denial in the 9th floor and the basement of that building where those confessions were extracted. And so we were unable to, the court was disallowed, or they admitted those confessions which were taken in those dark cells. And of course, that came to pass. They were convicted and sentenced to many years. Those days, it was not easy to get to proceedings to mount an appeal. And so, again, I was tasked with that duty of getting the proceedings typed as quickest as possible. It was not easy. And again, I encountered servant leadership from yet another Singh, Kata Singh, who volunteered his daughter to type all those proceedings in record time. And that's how we were able to appeal. And before we could even go for the first mention, the case was conceded by the prosecution. And the accused persons, after suffering for several years, were released from Kamiti prison. A few things happened which at that time shaped my mind to leave the country, including, after that, very fierce whole-day cross-examination of Senior Superintendent Mashiri, who is well known, giving threats to me personally in the corridors of justice. I'm followed with a morning raid at my office, small office that time, and I was taken to the the Director of Criminal Prosecution, where in the office of Noah Arab Tor. And I didn't know why. I was asked about a distress for rent case I had conducted lawfully, and I explained. I was told to go and bring the file from the office. I went and brought them the file, and Noah Arab Tor appeared to castigate his officers and told me to go away. It was clear in my mind. I had just gotten married. I had a young baby. I needed to leave this country at that point. And that is exactly what happened. At that time, then the Kingdom of Swaziland advertised for the positions of counsel in the DPP's office, in the daily newspapers of Kenya. And many young Kenyan advocates applied for those positions. I was one of them when interviews were conducted by the Attorney General and the DPP in Jubilee House right here. And that is when I was recruited as an expatriate Crown Counsel amongst 6 other Kenyans, Kioko Kilukumi and others, who you know. And off I started a career in the Kingdom of Swaziland as a DP, as a Crown Counsel, and later Senior Crown Counsel, conducting serious and vigorous. And that time, and until as late as 2005, the Kingdom of Swaziland and the the Court of Appeal, serving the Kingdom of Swaziland, Namib judges. So I had the privilege of practicing before very senior judges. That time, South Africa was on the crossroads just after attaining independence. And we had the Frelimo War on the other side of the border, and Mozambique. And so Swaziland had very many refugees and a lot of crime and gun running cases. And we gained, when you see people like Kioko Kilukumi perform the way they do, that's where they cut their teeth. And we were a team of Kenyans for Swaziland. And we left honor, which is evident until today. In 1998, at the age of 36 years, I was appointed Judge President of the Industrial Court of Swaziland. Until the year 2006. But really in 2002, after Kenya experienced that transformation, it's when I started thinking about coming back, and I gave notice that I had the intention of not renewing that last contract. But I faced a lot of opposition from the kingdom, who wanted me to stay until the last day. The Minister for Justice then, Prince David, who's brother to the king, walked with me up to the airport the last day, still asking me to stay and serve the kingdom. I did not say that in the same year I lost my father. And so being the bigger boy in our family, I felt also the need to come back to my country. And that's how I came back with a letter from my Chief Justice, Anadale, to the Chief Justice of Kenya, greetings, and asking if his judge could translate into the judiciary. I never passed the secretary's door with that letter. That is how far we've come in this country. And I was lucky to join the Federation of Kenya Employers as the head of legal and industrial affairs, where I served the employers diligently with honor. And in that year, actually, I had the privilege of sitting with all the stakeholders, parliamentary committees in finalizing the 2007 labor laws. So I was completely involved in the crafting of all the labor laws we have today. In that 1 year, I served in that for the Federation of Kenya Employers. I cut my teeth in collective bargaining and advocating for employers, engaging with the unions, and hence, I must say, I have got very good skills in conflict management, in consensus building, which I believe is very crucial in the office we are seeking today.
Maybe you can fast forward now to your position as a judge.
Yes. In the East Africa community, that is important. I'm Madam Chair, where I served and honed by diplomatic skills, consensus building. And actually, at the time I was appointed judge in the year 2012, I was in Brussels negotiating the economic partnerships with the European Union. That's when I received the news that I had been appointed judge. And I was actually not able to come for the swearing in because we were in these critical moments of negotiating the partnership with the European Union. So I came 3 months later after the judges of Employment and Labor Court had been sworn in July. I was able to come in October. They had been asked to elect their principal judge by Justice Mutunga, and they refused. They said they would not do so until I come back. They knew me because I had led them at the university. I didn't know them personally, but that is what they did. Actually, I remember Justice Kihara, commissioner here, had to be sent to them by the Chief Justice. And they told him also that they would wait for me to come back. And as soon as I came back, I was elected the principal judge of the Employment and Labor Court, which I guided very well from the labor ministry. It was a small court in the labor ministry. We had no offices, we had no furniture, we had no books, we had no seat in the judiciary. So I transitioned the Employment and Labor Court from the Ministry of Labor to the judiciary, and it was a formidable task. And we set up the systems and got the Employment and Labor Court to where it is today, including developing the rules, the charter, and getting the staff, because we didn't have any staff. All the staff in the Ministry of Labor, so it was a mammoth task, and with the assistance of the Chief Justice and CRJ, then we were able to achieve that, and even roll out the court to the stations in the various counties and establish up to 9 sub-registries. So those are the skills which have continued to hone today, which I believe make me suitable to serve the people of Kenya in the position of the Chief Justice.
Thank you, Your Honor. In an article appearing yesterday in the Study Nation by Gitau Warigi, and I quote, Your Honor, "The country needs a CJ with a vision, good temperament, and intellectual heft." So please explain to us, Your Honor, this statement by explaining your vision very briefly, also commenting on your temperament, and also commenting on the intellectual heft. Just briefly, Your Honor.
My vision for the judiciary of Kenya is to upscale and consolidate the gains so far in the access to justice and delivery of justice to the people of Kenya in an expeditious, fair, accountable manner, because that's the bottom line. All the other initiatives to do it are just enablers of that overriding objective to deliver justice to the people of Kenya in an expeditious, fair, equitable, inclusive manner, and in a friendly way, so that they feel wanted, because justice, the administration of justice, derives from the people, and our obligation in the judiciary is to serve the people. And so, as a Chief Justice, I want to have a blueprint consolidating judiciary transformation. And its key elements derive from both JTF and CJT, because all we are doing is to upscale this, access to justice, especially, and clearance of backlog, accelerate productivity of the judiciary staff, build confidence from court users, so that together we can have enhanced the rule of law in this country. We can enhance equity and equality in this country. So that so what do I do as a leader? With my blueprint, I will engage everyone to develop it. I believe in delegation and direct leadership. I believe in participatory initiatives, and then delegating to the teams. I believe in the teams I work with, and I have looked at I would work within the framework of the 2019-2023 strategic plan. I'm more concerned about the 2017-2022 ICT master plan, because I believe what will unlock the potential of this country is streamlining and escalating the automation of the courts, the e-filing system, the case tracking systems, the case management systems, basically the monitoring and evaluation systems. That is what will take this judiciary to the next level, and that is what will get the judiciary to productivity levels which will be make a big difference to the people of Kenya.
Okay, Your Honor, what about your temperament, just briefly, because those details will come later.
I am very easy to work with. I am very amiable. I found myself everywhere I've been easy, very easy and comfortable with people. I've not had difficulties in my court proceedings many a times. in all those years I have been a judge. And I believe I have built a lot of friendships across the judiciary and in the country at large, largely due to that emotional capacity I have to be in charge.
I will now request the Honorable DCJ to continue the questions.
My Lord, leadership, give us 4 strategic goals you would use to achieve organizational leadership and how you would implement the same.
I believe but the one I espouse most is leadership by objectives. Establishing a strategy, selling your strategy to the people, developing it into short-term, medium-term, and long-term work plans, developing smart objectives and deliverables, selling those, and then delegating generally to your teams to develop the work plans, providing also for the how those plans and objectives would be funded, and what capacity of personnel you need to implement your strategy in the short term, in the medium term, in the long term. That is the way I believe in dealing with leadership.
My Lord would not work alone and would not expect to succeed working alone. What teams would my Lord put together to assist in the optimum discharge of the judicial function and of the administrative function as Chief Justice?
First and foremost, I believe we need capacity in the office of the Chief Justice, first of all, because I've looked at the organogram, which is the strategic plan, and I've been wondering why there is nobody who works with the Chief Justice. I was told that the Chief Justice comes with his people and they are all on short-term contracts and they come and go with the Chief Justice. My proposal, and having worked in the East Africa community with the Secretary General, is first of all to have a few key officials in the office of the Chief Justice to enable him to enable myself with my strategy. First of all, as the leader of the third arm of government, it is very, very important where we are to be able to unlock the matters which hinder us today. And I'm proposing, first of all, that I would, if it's possible, to have a principal liaison officer on a permanent basis in the office of the Chief Justice. He will be serving under the Chief of Staff to unlock the diplomatic initiatives in that office, the consensus initiatives. I would also want to work with a principal resource mobilization officer to assist me in unlocking the financial crisis which we find ourselves, which hampers our programs. So, and with that, I would also want to have a principal legal officer, a tripartite working in that office on a permanent basis, really, in addition to the other hand-hoc officers. That was my experience with the East Africa community, and that's why They are funded 50% by the partner states. And we have to fund that organization through development partners, through that office, sitting in the office of the Secretary General to mobilize funds. And I think that, to me, that model would work very well for me. The key team in the judiciary also is the judges themselves, the magistrates themselves. You cannot achieve anything in the judiciary without them. They are my colleagues, my peers. I'll be only first among equals. One of my first initiatives will be, having looked at the report, the staff satisfaction survey 2018. I've also looked at the court users satisfaction survey 2019. I've identified areas of dissatisfaction which I would want to address as a matter of urgency.
Yes, my Lord, in fact, thank you for flowing into that area, because that's my second area of concern. So what have you identified from there? What is first the purpose of those employee satisfaction surveys? And what are you bringing in here, my Lord, as CJ, to right the situation from where it is?
First of all, I must appreciate that the satisfaction levels of staff and the court users are very high, contrary to the general perception out there. Actually, I was surprised looking at the percentages in every area. It looks like in almost 99% of the areas, the levels of satisfaction are so high. And that is why sometimes you wonder why the general perception out there appears so bad when a scientific survey shows a very high level of satisfaction. However, I identified key areas. With the court users, the matter is the time which it takes from the filing of the case to its conclusion. That's the main issue, really. That is where there is dissatisfaction. And that is the core of every initiative that the Chief Justice should embark on to unlock the potential of the judiciary, unleash it, so that we can increase the capacity of the judiciary to deal with the backlog. 2 years, 3 years, 4 years is bad for some dispensation of justice. And so the initiatives which are in the strategic plan include and the key enabler, in my own view, is the master plan, the ICT master plan.
My Lord, there are two issues here. There is the employee satisfaction, then there is the customer.
I was coming back now to the staff.
Okay.
With regard to the staff, and especially the magistracy and the judges, also I identified two key areas of dissatisfaction: the promotion procedure and career progression procedure. The levels of dissatisfaction with that, in my view, especially the promotion, appeared to be very low, and I believe I would want to engage that area and have a document developed in a transparent manner to be implemented to completely deal with the promotion and career progression of staff, judicial staff in the judiciary. The other area I identified is the disciplinary dispute resolution procedure, which actually is not even an indicator in that survey. Such an important issue, it was left out completely. Yet, this is a cause of staff suing their employer, judicial officers suing their employer, judges suing their employer, because they are not, and we don't have a framework of dispute resolution. We don't have a framework of sorting out dissatisfaction within the judiciary. We don't have the procedure of disciplining especially the magistrates and other judicial. It's not transparent, it's not known. And if it is there, I must say it is not known. And that is the cause of so much dissatisfaction. I would want to address that as a matter of urgency.
My Lord, the magistracy include the Kadhi.
Yes, they do include the Kadhi.
There was some discussion pre-2010 constitution about the Kadhi's court. Please tell us what that was, and today tell us the structural scheme we have in the judiciary about the Kadhi's court, the challenges they face, and whether truly they are part of the judiciary.
I must admit that I'm not very vast in that area, but I will say this, that I know for sure that the process of recruitment of a Kadhi is not well streamlined in the judiciary. And there's dissatisfaction in that area, in the manner the chief Kadhi is appointed. There was also discussion on how far the special needs of the Muslim community, and especially those dealt with within the judicial system, will be catered for without violating their rights as a Muslim community in Kenya and in the world at large. I believe those are the concerns which Kenyans continue to engage in, so that Kadhis, who are equal partners, equal citizens, equal Kenyans, I mean the Muslim community, are treated equally, fairly, in the way, in every aspect.
My Lord, as Chief Justice, that would be your concern to settle, as would the Court Users Committee functions and their performance, because my Lord would, of course, be the chair, the National Council on the Administration of Justice. Please tell us what the impact of CUCs has been to date, and how their performance is to honestly be assessed.
I noted that also as an area of dissatisfaction in the survey, that especially awareness. There's a big issue of awareness by the people of Kenya as to the existence of CUC.
What are CUCs?
I thought we are talking about the court users committees.
That's right. I'm saying you explain to us what those CUCs are, and under your leadership as both Chief Justice and Chair, how you would make them perform. Of course, you would answer that question with telling us what they are doing right now, and how we would be able to assess their performance in improving access to justice.
Thank you very much. As the principal judge of Employment and Labor Court, I started the Court Users Committee for that court. I was also able to start the Court Users Committee for the Labor Court, in Kisumu, not to activate it because it was dormant when I went there. And so I have a very good understanding of how the judiciary should interact with its key stakeholders to resolve especially the areas of dissatisfaction. And that is usually the CUCs, regular meetings with all the spectrum of stakeholders to where they give feedback to the judiciary, and judiciary answers their concerns, and we work out sometimes training programs, and together we agree on manners, ways of resolving the problematic areas, especially the interfaces between the judiciary and the court users, which are problematic, especially the access to the registry, the facilities they use, accessible to them in the judiciary, taking care of the needs of the people with disabilities, dealing with issues of rudeness, issues of bribery, if they arise, and corruption. And so the satisfaction by the Kenyans will improve by the day as we enhance the capacity of the CUCs to deal with emerging issues. And when we do, because I believe we have been doing it, but also we don't talk very much about what we are doing. And that is why I saw in the survey that a lot of stakeholders were unaware that they in fact do exist. We had, for example, the marches during the Mutunga time. We had we have open days as models of the engagement mooted out by CUC. In fact, Madam Commissioner, when I was at the ELRC, I started the first Inns of Court in Nairobi, which is still working today between the bar and the bench. And I had several engagements through the Inns of Court, which I started as a principal judge and which has been taken up by the current leadership, and it continues.
All right. My Lord, please tell us, as Chief Justice, my Lord would wear very many hats, at the minimum 5. Which of those does my Lord consider to be the most important, if that's possible? And how does my Lord hope to better the judiciary by the importance of that role?
The Chief Justice is the embodiment of the leadership and the institution of the judiciary. He is the face of the judiciary to the Kenyans who gave that authority unto us. So the Chief Justice as the leader of the judiciary, and the way he handles his internal affairs and external interactions with key stakeholders is the most important function of the Chief Justice, because those interactions will determine the internal satisfaction with his teams and the external satisfaction with out there, and to a large extent determine whether we are able to mobilize funds to achieve our objectives. We are able to get, for example, the issue of 41 judges unlocked. That role of the Chief Justice, the ability to build consensus as a leader and the embodiment of this institution is key and paramount. And you need a person who can be able to do that in a most judicious manner and amiable, diplomatic manner, yet decisive and honorable.
My Lord has sat in the Employment and Labor Relations Court since 2012.
Yes, my Lord.
As my Lord developed a particular type of judicial philosophy from my Lord's tenure at the court, if the answer is yes, how does that impact on my Lord as Chief Justice, particularly on employer-employee relations?
Madam Commissioner, I would not say that I have developed a particular philosophy other than what has been and a philosophy in me in every place I have worked. To administer justice in a fair, equitable manner, to treat people with courtesy, humility, and to make judgments which reflect the values, principles, and purpose espoused in our Constitution. Indeed, Madam Commissioner, the ethics of our Constitution guide us in the way we interpret our law, in the way we implement our laws. Those are commands which we must have in mind all the time. And so, I just espouse the constitutional dictates, the principles developed over the years by the nations and the ILO, which have been adopted in this country as guides of what we call decent work and gender and human rights infused employment. Those are dear to me, and their values which are neutral and not biased in any way.
All right, thank you, my Lord. Now, is there a disconnect between the law and society? In case your answer is yes, how does my Lord as Chief Justice and leading an able team of judges and magistrates intend to reconnect law and society?
In fact, this builds on from where we were with the interfaces between the judiciary and the court users, because the court users are the embodiment of the society out there. So that is going on and is going to be escalated, and the communication channels, especially how we communicate the good things we do, because there's so many good things we do as a judiciary since JTF and SJT, I believe. And under the guidance of these commissioners too, there are very good things which you do. How well we communicate this will be part of my communication strategy to the people of Kenya. There is the issue of education and training within and without. And there must be also interaction in those trainings. We should also have joint trainings with the people out there, stakeholders. I believe that there's room for that, for training as we engage. I believe there's room for social awareness training of our judges. Social awareness training focuses on the values and the principles and the culture of the people, which of necessity a judge must be aware of as they dispense justice. And it's in that understanding that our decisions will become better and serve the people of Kenya more and more. I believe in that dearly, and I would embrace it fully as a Chief Justice.
Thank you, my Lord. As One of the major roles of the Chief Justice, one of the 5 I mentioned earlier, is being President of the Supreme Court and being the jurisprudential head of the entire institution. My Lord is aware that there is a difference between criticism and critique. So would my Lord first critique the performance of the Supreme Court to date? It's 10 years old. And 2, how would my Lord, as President of the court, bring a difference in that court?
I am aware that the Chief Justice, you are also the President of the Supreme Court, and therefore the first among equals in that court. I'm also aware that I have very senior judges in that court, many of whom I have personal interactions with, because as I said, I am very easy with interactions, be they upwards or downwards. So I also have studied and I do use many of the judgments of the Supreme Court in my decisions. And I know, for example, I can identify some decisions which I think have not stood well in my own. The first one, which has given us a lot of problems at the E&LLC and in the magistracy, is the Law Society decision on Weber. That decision, my problem is with the effectiveness of the orders often discharged, issued by the Supreme Court. Not only in that case, in Mitubel case, and in Morowateto case, very good jurisprudence, but in my own view, that more needed to be done, especially in crafting effective orders, because justice orders are not issued just for the sake of it. Justice is dispensed to sort out problems in society. And therefore, the other day, just before Justice Maraga left, we had concerted efforts for him to explain to us in the ELRC and within the magistrates the meaning of that decision, Supreme Court decision, because it has created a lot of confusion across the board in the handling of Weber matters.
Weber. Mm-hmm.
Yes, it's a problem. So those are the issues, and up to now, and that will be, I would want to give that attention as soon as I am Chief Justice.
It is that I am looking for the benefit of all of us.
Yes.
So what are you going, my Lord, to do as the jurisprudential head of the judiciary and of the court of the Supreme Court in particular? What are you going to do so that Weber does not happen again, if according to you Weber is not good jurisprudence, and Muratetu does not happen again, if according to you Muratetu is not good jurisprudence? What is the role of my Lord as President?
First of all, I'll clarify about Muratetu. My concern is not the decision itself, but how far the Court of Appeal went in having resolved very well, dealt with the issue of mandatory the death. I mean, say mandatory, that declaring death sentence and as not a mandatory sentence. It's how far I thought they should have gone to deal with minimum sentences which are as harmful to the people of Kenya, especially in matters sexual offenses, and also there's also the issue which I don't know how it was addressed as to the
So
place.
how would my lord address it as president of the court?
We are collegial as judges of the Supreme Court. We sit in caucuses. We meet in colloquiums and we purpose to engage in manners, in areas where we could improve the jurisprudence. And that's my approach, being a very democratic leader, a very collegial leader, would be to want to utilize the jurisdiction of the Supreme Court to revisit its own decisions. I know some of those matters will come again because we have decisions being made at the lower level, which will come back again, and so there will be opportunity to revisit some of those issues, coming again through the High Court to the Court of Appeal. So there's that opportunity. And when we get those opportunities, it will be my time to use my collegial engagements, in my view, very good qualities, which I have to create consensus within the law, and I also like good dissent, because it is in those decisions where we develop our jurisprudence. So my ability, Madam Commissioner, in building consensus, which I will do with all those judges there, and they are all my friends without exception. In that, I have had workings with them, including you, Madam Chairman, in the JLAC. I've worked with you in morning meetings for a long time. I've worked with each one of those judges. I know them personally.
True.
And I am able to easily deal with them at that level.
Thank you, my lord. Finally, from this end, that court, once every 5 years, is likely to hear the presidential election petition. Do you know what the court may have done in the last 1 year to improve its preparedness in discussing that major petition that comes once every 5 years? Part 1 of the question. Part 2, what would my lord say has been the success or lack of it in the manner the court has handled the last 3 presidential election petitions?
I know, as a matter of fact, that we have Supreme Court Rules 2020, I believe, which have been developed to better the procedures of the court. And since that is the main mandate of the court, I believe that will aid in handling of. We have the Supreme Court elections rules also, which I believe have been tackled in that process to improve the manner in which the court handles.
Any specific one, my lord?
Yes.
Any specific one?
Specific?
Any specific rule you are talking about, my lord?
I believe I have come across the Supreme Court Rules 2020, if I'm not wrong, in my readings, and which I suppose is an improvement on the previous rules of the court. And although I have not had an extensive interaction with the specific rules which have been developed, and you would understand why, being how busy we are at the level we serve. So we tend to engage with the Supreme Court matters when they directly affect the issues we are dealing with. But for the purposes of preparing for this interview, I believe I've interacted with new initiatives in that court. in development of regulations and rules, which I believe will help in the improving the capacity to handle future election petitions. Then coming to the issue of the petitions, I have interacted with 2013. Is it 2013? Rider 1. I've interacted with Rider 2. The 2017 ones, and my issue is that there is uncertainty in the law of resolving presidential elections arising from those two landmark decisions, the Mutunga one and the Maraga one. And the Supreme Court has got the mandate to depart from its own decisions, and so there's nothing wrong with areas of disparity because they are permissible in interpreting, especially in interpreting Section 83 of the Elections Act vis-a-vis the Constitution, and the meaning of the impact of transmission of votes from the polling stations to the tallying centers to the national sector, how that impacts the election and the final decision result. I think these areas of disparity in how the Supreme Court went about those issues in the Mutunga case and in the, I call it the Maraga case, Rider 1, Rider 2, and the values, the principles in the Constitution, how they were applied to the election process, the importance of the polling station as a primary area of universal suffrage where the people speak, vis-a-vis irregularities which might occur along the way, how we, I believe those are the areas which of disparity in those decisions, and jurisprudence will develop as we move on in those areas, no doubt, Madam Commissioner.
Thank you, my Lord. Thank you, Chair.
Thank you, Honorable Acting CJ. I now request Commissioner Honorable Judge Wasame to continue with the technical questions.
Thank you very much, Prof. Chair. My Lord, my questions will be based on the issues you raised with the Honorable DCJ Acting Chief Justice. And I think also with the Professor. You said you left the country because
yes,
you felt your life was threatened, isn't it?
Partly.
Partly.
Yes.
Simply because you were called to the office of the DCI.
If you knew who Senior Superintendent Mashiri was, if you interacted with the...
There are more of them currently.
If
so
you knew, Commissioner, with what was happening at that time of our history, and having received real threats in the corridors of this justice, this corridors of this court, while discharging my duties as an advocate, as a very young lawyer, by the way, at the age of 28, you would understand where I'm coming from. But more importantly, I left because also an opportunity arose because the Kingdom of Swaziland advertised for positions in this country for us to apply.
So is Chief Justice Nduma Nderi a person who is, every time he's intimidated or threatened, is likely to leave the jurisdiction of the country?
Not at all, not at all, Chairman. I'm very courageous. I'm absolutely courageous. To take that role I took in that, at that time of our history, very, very few would have dared do that. I can guarantee you. When I had my wedding, at that time, because at the same time when I married, most of my friends could not even dare attend the wedding. It's only the people I was working with at that time who had the courage to come at St. Paul's Chapel to witness that wedding. That's not a period anyone can take for granted. We know what happened to the people of Kenya at that time.
Okay, my Lord, when you are answering the Honorable DCJ Acting Chief Justice, you said there is uncertainty and disparity in the jurisprudence in terms of the election petitions or decisions rendered by the Supreme Court in Raila 1 and Raila 2. Can you tell us two disparities or uncertainties that is apparent in your view from those two judgments? And I'm just quoting what you said, my Lord.
First of all, Commissioner, the interpretation of Section 83 of the Elections Act and its impact on the election process, the use of the term and all, and whether it's conjunctive or injunctive, and therefore whether one who wants elections to be nullified needs to show that there was a violation of law and constitution, and that only suffices to nullify an election. Or they must go ahead and show that those contraventions in the law and the constitution did in fact impact the actual votes. That's an area of disparity in those two decisions. The other area of disparity is the weight, the fact that in the Maraga, in the Raila 2, we had changed our rules, election rules, and introduced peculiar electronic rules in the Elections Act. And therefore, the issue of transmission of votes was very prominent in Raila 2. It was not in Raila 1. And to a large extent, that impacted the way the judges decided those two matters. Those, in my view, are two key areas of disparity.
Okay. The Supreme Court is allowed to depart from its earlier decision. Would CJ Nduma Nderi depart from Maraga 1?
If I became CJ,
Yes. God willing.
God willing, that very heavy responsibility will be thrust upon me. And if I were to state my position right here, I think that will not augur very well for my sitting in those cases. So I do appreciate very much your concern, but I would want to reserve, not to answer that directly. But as judges, we must keep on exploring our own decisions, because the Constitution gave that mandate to us. And therefore, we can change today's decision tomorrow, depending on the circumstances and the facts and understanding of the law, the interpretation of the Morgan case and how it was applied, for example, in Raida 2. I mean, really, they used the understanding of and the ones used. Those are areas which judges will engage in and fitam.
Okay, which means, my lord, you are not willing to take a position on Maraga 1 and Mutunga.
I think it is not right for any judge to do that.
Okay, fine. In Mutunga 1, in Mutunga case 2013, the Supreme Court used the words burden of proof, standard of proof, and evidential proof interchangeably with respect. What do you understand by those terms? And what do you think is the standard of proof in election matters, especially presidential? And presidential election is unique, my lord, it's not an ordinary election matter.
That is, my lord, very correctly another area of disparity in those two decisions. The standard of proof, whether is it the intermediary one, whether it is on a balance of probability. There is disparity in the way that was handled in the two cases. The way it came out in the Mutunga case was not very, very clear to me. That intermediary test, which was developed in that case, it's not definitive and has leaves room for divergent discourse and consideration. And I believe Maraga 2 did engage extensively on that, and they arrived at a differently crafted test. I do not know whether it is intermediary or it's on a balance of probabilities. But the test in Maraga 2, the determining factor was factual. The facts that they stand dictate that we decide that the dictates, the principles in the Constitution were not adhered to. And I think when you deal with us, with the standards of proof described in so many words, it has to be on a case-by-case basis to unravel what the true test is. And so that uncertainty persists, in my view, of what standard is applicable in an election petition.
My lord, we want to get your position, and that's what the Honorable DCJ was asking. What, in your view, should be the standard of proof in presidential petition against ordinary election petitions involving MCS, members of parliament, governors, and senators? What should be the standard of proof in one side and the other side? And now that you are presiding as the Chief Justice Nduma Nderi, God willing, 2022.
The standard of proof in civil matters and electoral matters should not differ, in my view, whether at the parliamentary stage or the presidential stage. Strictly speaking, these are civil matters, and the principle, the burden of proof. But with regard, we are very well guided on how to deal with these issues in terms of Section 83 and the relevant provisions in the Constitution. We have the principles which tell us that constitutional edicts which say that this standard of accuracy, transparency must be achieved for an election to be free and fair. And therefore, when you infuse the constitutional edicts into the, while interpreting Section 83, I think the matter should be very clear. But as we always say that the law is very clear. But when we get into the discourse, it becomes not clear. But I believe, in my view, the dictates of the Constitution must prevail all the time, because we give it to ourselves, and we must adhere to those standards which are contained in that Constitution we gave ourselves. The values, the principles, and that is what impacts the manner in which we interpret that we arrive at the standard of proof in that presidential election. And I do not believe that those edicts apply only to presidential elections. They apply across the board. Only that the Supreme Court has expanded its jurisdiction to deal with parliamentary matters, which were supposed to end at the Court of Appeal level. And so there was not going to be an area of disjoint if the Supreme Court had stuck to its jurisdiction given to it expressly in the Constitution. I believe there was a bit of craft in the extension of jurisdiction of the Supreme Court to deal with parliamentary elections.
Why I'm asking, my Lord, and I'm consistent, is that in a presidential petition, the case is decided on affidavits filed by the respective parties. There is no cross-examination. There is no re-examination to trace the veracity and the truthfulness of the evidence proffered by the parties. While in ordinary election petitions, everything is tested through cross-examination. And as a judge doing trial, you will be able to know who is telling the truth. Therefore, is it necessary for us to separate the standard of proof in ordinary election petition from that of presidential petition? That's what the question I'm asking. And I want you to give some highlights.
From where I come from, I hold the view that the principle, the manner in which an election should be conducted at every level, as found first of all in the Constitution, and the principles, the procedure that must be followed, is a guide as to the standard which of proof that must be applied by the court. If the edicts of the Constitution are mandatory and we are enjoined to implement and enforce all of them, I believe there should not be no area of disparity in presidential and parliamentary elections. Only that the statutory provisions guiding the statutory provisions guiding the processes may differ. No, they don't differ, because yes, they do, and the difference in any statutory provision should not impact the edicts of the Constitution, because that is the base. And so, while saying that parliamentary elections ought not to have gone to the Supreme Court in the first place, I believe that the standard of proof should remain universal, as we gave to ourselves in the Constitution.
Okay. You said you have wide experience in labor matters, and you are one of the most experienced judges, as you said, having been presiding judge in this country almost 4 years. You also worked outside the country, so you have a lot of labor knowledge.
4 years, my lord.
As a presiding judge.
5 years.
5 years, okay.
Yes.
5 years. Thank you for the correction. Are you a judge who treats everybody equally and fair?
I have never known otherwise. I do that all the time. And every person is fallible though. And the thing is, well, as a judge, you exercise your decisional independence, and litigation, unlike mediation or other out-of-court methods of settlement, all the time, and most of the time, is for one person and not the other. And so, people will always express dissatisfaction with the decisions which come from the court. Because when they come to court, they have high expectation that the decision will go their way. And therefore, and that is the exact reason why the decisional independence of a judge is paramount. Otherwise, the judiciary will be haunted forever. The judges will be restless. They will be haunted, as is happening, and it is happening right now. Haunted by their decisions. Instead of people going on appeal when they are not happy with their decision, they file a complaint. And that is why, and I forgot, when I was being asked questions I didn't forget, I'm very concerned about the vetting process of complaints before they get to the JSC. No, before, and by the JSC, before they graduate to a disciplinary, to a process, an inquest, where a judge is required to come and defend himself. That vetting mechanism, I would want to pay a lot of attention to it, because I believe it has become a big cause of concern to the constituency of judges and magistrates in this country. Because, again, there's no document which tells us the standard of required for a matter to graduate from a committee. Like happened during Mutunga's time, we had the committee chaired by Supreme Court Judge Wanjala. And at that time, being the principle of the Employment and Labor Code, that committee interacted with me continuously when complaints came from my court. So they made me aware of it, and in those interactions, almost all matters which would have otherwise graduated into judges being summoned before the JSC were resolved. And so my suggestion is that the heads of courts, the principal judges, the heads of state divisions, the judges, very senior and honorable, should be involved initially by that JSC committee in the vetting process, and to find out whether the genuineness of these complaints, and whether in fact these are matters which are an attack on the decisional independence of a judge. And I must tell you that once a judge has been summoned to appear before the JSC to answer to charges, the amount of time you take a lot of time out of your work to dedicate yourself to that matter. We hire lawyers all the time to come and defend ourselves, and judges are paying the suffering in that respect I would want a transparent vetting mechanism, as happened, although it was not documented during the tenure of Justice Wanjala. There is evidence that almost all those matters never arrived to be considered fully by JSC. That is my answer to this question. And that is why we are inundated every day with complaints which ought to be appeals to the next level. How are we supposed to work as judges? Because the time you take out of your schedules to give justice to the people is entirely now dedicated to a matter before JSC. And if you're going to have 10, 20 judges appearing before JSC at any one given time, the psychological trauma the judges go through, I as a Chief Justice would want to address that as a matter of urgency in developing a transparent vetting criteria, taking into account that the people, we serve the people and we are also the people, and we should not be haunted because of the mandate that they have given unto us. And that is my belief, Commissioner.
Okay. My Lord, I request you pay attention to this quote made by a judge. With the greatest respect and at the risk with the greatest respect and at the risk, unfortunately, of appearing uncharitable to the learned judge, his judgment was somewhat conflated, not least because it was difficult with great circumspection to discern the findings of the court and the reasoning thereof, as opposed to the submission of the counsel and the pleadings in the case. The learned trial judge was enjoined to be dispassionate and was required to be guided by the facts emerging from the evidence in the case and to apply correctly the law to such facts. He was bound to adhere inter alia to the national values and the principles under Article 10 of the Constitution. It was not in the purview of his jurisdiction to engage in speculation or conjecture, much less to show partiality in the dispute. A judge should never take sides or be guided by extraneous matters. A judge is required to be guided by the evidence before him, from which facts emerge to which he or she should properly apply the law. A judge should not be intimidated or be influenced in his decision by status, wealth, power, or influence of a party, and a weaker party does not have greater rights by dint of his or her station in life, though the court may be more sympathetic to such party. In a nutshell, litigants are equal in the eyes of the law, and none has greater rights than the other. The Constitution enjoins every judicial officer to be fair and serve justice to all without jurisdiction. Is that a reflection of you?
That is the Cholet matter, which
I didn't say it's the Cholet
matter.
That
is the Cholet matter which I decided.
Yes.
And I remember those very words from one judge who sat in that Court of Appeal panel, which dealt with that decision in the Cholet matter. And the way I understand the role of a Court of Appeal judge, and we have a lot of writings on that. Sorry. My understanding of the role of a Court of Appeal judge, Court of Appeal judge should never ever be involved in that kind of frolic about a judge who handled a matter below him. To me, that was completely out of step. All the other judges in that panel considered that matter in a very considerate way. And I believe, in my view, that particular judge was guilty of the very things he was talking about there. And that is one matter which I still believe ought to have gone to the Supreme Court, so that all those issues are dealt with, so that we know who indeed was partial and who was impartial in that matter. That is my belief.
Okay. Again, one of the other judges also described you like this. I don't know whether you agree. It is clear from the phraseology employed by the learned judge that he took an extremely dim view of the manner in which the appellant dealt with the disciplinary process that led to the removal of the first respondent. The learned judge considered the entire process as fatally flawed and contrary to the law. He saw this as asymptomatic of an enthusiastic and insistent, overzealous, even attempt by the appellant and its chairman in the person of the Honorable Chief Justice to hear the matter and deal with the first respondent in a partial manner, even if it meant breaching the law in the process. With respect to the learned judge, he appears to have floundered in the same marshy bog of erroneous zeal with which he charged the appellant, and that is why the learned judge collapsed and conflated two separate and distinct disciplinary processes and mistakenly used the statutory markers of one of the tests to the other with the inescapable consequence of erroneous conclusion. Is that a reflection of you?
Commissioner, I must first of all say that...
and that's also another judge, it's not one of the judges.
Commissioner, I know you are involved in that matter as a commissioner. And I know it involved the judiciary as a family, and some people have taken diverse views on what happened within our judicial family, and so a lot of emotions were expressed, not just in a judicial decisions that were made at my level and the Court of Appeal, which reflect largely what some of the wordings used. But I must say, and I repeat again, this I believe is a decision we should have gone to the Supreme Court, because I believe there was a lot of partisanism in the way the matter was handled. And a judgment, how do you judge your colleague? How do you pontificate against your colleague? We are guided against that all the time in the principles which we espouse as judges and a family of judges. So I disagree with all those sentiments.
You disagree with those sentiments?
Yes.
Okay. In paragraph 125 of your judgment, this is what you said also. It is difficult to understand the shortcut taken by the very eminent papers of the legal profession in a situation where the mandatory procedure that will have been followed speaks so loudly from the express provisions of Section 32 and Regulation 25 of the Judicial Service Act 2011. That's what you said.
Again, I say, Commissioner, you are involved in that decision.
Now, which
I criticized. You are involved in it, Commissioner. And again, I say this is a decision we should have gone to the Supreme Court. I do not agree.
You do not agree with your own statement?
I do not. I mean, that was a judicial decision which I believe will stand the test of time in academia. And that is where it belongs, because it was impugned. Okay. And I don't have to answer for it, but posterity will, and academia will. And if it ever sees the light of the day, if it had seen the light of the day at the Supreme Court, maybe we'll be talking a different story. So, Commissioner, in a matter where you are involved, I think you should not take so much time on it, because you also have personal views about it.
Okay. I have no personal views, but let me ask you, leave alone the language used by yourself and the judges, and let's come to, and that's why I said we want to test your understanding of the law. And in this case, you equated disciplinary matters to that of a criminal trial. And you used, I think, the law of criminal trial in all its aspects, and that what you overturned. Is that the position?
Completely misunderstood by the Court of Appeal decision. It's not true. That is not my understanding.
So you don't.
And I'm saying again, you are involved in that matter. You cannot have an objective judgment about what I said there. It's only an independent tribunal, in this case the Supreme Court, which can pass judgment.
So you completely don't agree with the decision of the Court of Appeal, and I will leave it there.
I don't agree with it. I'm bound by it. I don't agree with it. Well, I'm not supposed to agree with it.
I wish you well, my lord.
Thank you, Commissioner.
Just a small clarification, Your Honor. You talk really passionately about judges who appear before JSC. But just also to clarify, there's so many complaints that come to JSC, Your Honor, which we don't escalate to even to the judges, because we find they are merit-based or they are at the discretion of the judge. So I just wanted to put that information to just clarify. There are many that come and we don't escalate, but there are some that we find that the judges need to come and explain. So I don't know what you feel about that.
Thank you. Thank you.
Because there are also complainants who really bring genuine complaints, Your Honor. I'm sure you agree that some of the complainants who have come to us have really genuine cases that we must address.
Madam Chair, my concern is what I would want to be done is to have a transparent criteria developed so that there's certainty in that area. And especially we know the place of decision of making independence of a judge in the way that those complaints are handled. And that can only come up in a criteria developed through a consultative process involving the judges themselves. Because believe you me, commissioners, it's taking a lot of effort from the judges' constituency, so much of it, and taking them away from their work when they should be serving the public. Those many matters, having spent so many hours, and most of those matters eventually are dismissed by JSC, the public is suffering. When you take for example, a whole 8 months dealing with a matter, hiring an advocate, and you don't get costs in that process.
Point is noted, Your Honor. I now turn to Honorable Commissioner Judge Majaja to ask his questions.
Thank you, Chair. Good morning, my Lord. Before I deal with your writings, I just want to follow up on what my fellow two commissioners have talked about, particularly two things. You talked about the Weber case and the Muruateto case. Maybe briefly, just tell us, what do you think is the role of remedies in the whole question of legal transformation, in your view, in terms of the remedies the Supreme Court gives or the High Court or your court gives in terms of achieving the goals of transformation? Maybe you just explain to us briefly.
First of all, remedies coming from court must be clear and effective for purposes of implementation. Two, those remedies must adhere to the edicts of the Constitution to advance those areas which the Constitution zeroed on for the people of Kenya to advance.
Okay, so in Weber case, what was the remedy? Maybe you tell us and the public, what was the remedy given by the Supreme Court?
In the Weber case, the court nullified or upheld the decision of the Court of Appeal, which had nullified the High Court decision, declaring parts of the Weber unconstitutional. And therefore, we got back to the original position where work injury disputes work injuries should be dealt with by the director, and they should only come to the courts on appeal.
So basically what the Supreme Court, if I understand, was that it was asserting the mode of alternative dispute resolution, isn't it? At the end of the day, it was saying, look, Parliament has created a mode of resolving disputes. This is the mode, and we are upholding it. Am I correct on that?
The remedy came short.
No. That was the issue, really. I'm not talking about the remedy. First, let us understand the issue.
The Supreme Court upheld the view that there was nothing wrong with the compensation within the process in the WIBA, and therefore we should all resort to it.
Yes.
So
basically they were saying there's an alternative process.
Yes.
And that process should be upheld, isn't it?
Absolutely.
So what was, and that you agree is part of the constitutional...
and I agree with that decision fully.
Okay. So what is the problem with the remedy? What was the remedy? The remedy itself?
The remedy was... the issue is that at that particular time, we had many matters pending in court. Hundreds of matters, if not thousands, pending before the magistrate courts and pending before E and LRC, filed at different times and were awaiting conclusion. So there's an issue of now, how do we deal with matters which were dealt with before the promulgation of WIBA in 2007? How do we deal with matters which were filed after the promulgation of WIBA, but before the act was nullified by the High Court?
Okay.
How do we deal with matters which were filed before the determination of the Court of Appeal?
So basically what you wanted is the court to give a structured approach.
A structured remedy which now would inform the magistracy, which is holding so many matters and dealing with them in different ways. So and that is why we actually, the court, the principal judge in our court, wrote to the Chief Justice asking him, please give us clarity so that we know what the magistrates should do with these matters which are pending before them, so that we know what we should do with matters, because we are getting different courts dealing with the matters differently because there was no clarity in the judgment. Okay. Now, don't you think that also it is the responsibility of your court dealing ex cathedra, dealing with matters, because the Supreme Court has said, basically it has said, this is the process. Don't you think now it is the role of your court to say, or to deal with the cases on a case-to-case basis, like you are interpreting the Constitution, say, okay, the Court of Appeal has said, the Supreme Court has said this, therefore, if a matter comes before us, those are now the issues the court should consider and give, so that it is now also your responsibility as a court dealing with these issues to give direction. And that is exactly what ELRC is doing. But of course, the different judges coming up with different approaches. The magistrates are at the same time also dealing with matters before them in a different way. So we've had caucuses with the Law Society because they have been, and the stakeholders are also very frustrated about the way they are being handled by different courts on that matter. And we are saying that having had initiatives, the Chief Justice with the stakeholders to resolve the issue, and up to now, there is no satisfaction, especially from the court users. Then we have to wait for our individual decisions, which we are making, to go all the way back to the Supreme Court. How long will it take? Okay. How long? And that brings us to the other question. In such circumstances as the Chief Justice, first of all, you are the head of a CUC. There is a problem which now you agree the court may not be able to solve.
and on the other hand, you're engaging with stakeholders, FKE, COTU. What is, because I get the feeling sometimes in Kenya, we want to dump everything on the judiciary to resolve, and you as the Chief Justice, what is your role in telling the stakeholders, telling them, look, this is actually a matter for legislative intervention, for example. Go and make the law. The Supreme Court has said we have a problem. So how do you, as the Chief Justice, deal with that particular issue? Because if we say the case reaching the Supreme Court actually means that somebody has to appeal, and you know the people dealing with those kind of cases have no interest. These cases are small, and they have no interest in waiting for 3-4 years. So what is your role as a Chief Justice?
If I'm appointed Chief Justice, I will deal with it, engage with the matter immediately, because I know it is hurting.
Okay.
And I will take a stakeholder approach to try and deal with it and resolve it.
Okay. And Murwatetu case, what was the problem with the relief in that case?
First of all, I know. I mean, when we were in school, I mean, learning law and reading landmark decisions of great judges, there's a role of obiter dicta in great landmark decisions, where it is clear to the court that a decision being made is likely to impact many other situations, such as minimum.
So in Murwatetu's case, the ratio was about the death penalty, relating to the two people, isn't it?
Yes.
The applicants. But as a court, one of the objectives of the court is to develop jurisprudence.
Yes.
And to give appropriate relief. Appropriate relief. In your view, how does that jurisdiction to grant appropriate relief gel with the duty of the court to develop jurisprudence? When you're confronted with such a matter, how do the two relate?
Commissioner, that is what I was saying in different words, to develop the law. The obligation of the Supreme Court, being the apex court, to seize those opportunities which come so rarely, to then develop the law to deal with the problematic areas.
And so you agree that is actually what this Murwatetu did?
But why are we having a problem with the minimum sentences in critical areas which were not even touched in dicta?
Well, let me put it this way. What did the Supreme Court say in Murwatetu? Why did it say that the minimum, mandatory minimum sentence, mandatory death sentence is unconstitutional? Why did it say so?
Because it takes away the discretion of a judge.
Based on what provisions of the Constitution?
Based on the first of all, the decisional independence of discretion of a judge to weigh the facts of a case and arrive at an appropriate decision, which discretion is also taken away in every situation where you are faced with a minimum sentence. To me, that was a cardinal issue here.
That was the cardinal issue.
Yes.
So in the sexual offences cases and the sentencing, what is the problem there?
The problem is that the discretion of the judge to deal with facts of each case on their merit.
So you agree that in fact Murwatetu's case opened the door for resolution of minimum sentences?
Opened the door, but it was not definitive.
It was not definitive in what ways? Because you're saying the court has said the court has to have discretion. So are there cases where the court should not have discretion in sentencing, and if so, what is the constitutional basis for that argument?
If indeed then that has been taken out, is if that decision opened that path to deal with all similar cases, not necessarily death sentence, then I would say then the criticism may be unfounded.
Thank you. So let us go to the next, your writings. You have brought for us very good cases on the judgments you have delivered. I'll just go through each of them and ask you a few questions. The first case is about, it was a three-judge bench about the payment of agency fees for persons who benefit from union services but are not members of the union. Am I correct?
Yes.
And in the West, it's a very contentious issue. They call it right to work.
Yes.
Right to work. And two judges upheld it and one judge dissented. Just a small issue I want to ask you. You used a lot of, you made reference, both the majority and the minority made reference to jurisprudence from other jurisdictions extensively. And in fact, it's a hallmark of your court to refer to jurisprudence from other jurisdictions, international treaties and standards. What would you say about the concept or the doctrine of what I would call constitutional borrowing as it relates to the work of the Supreme Court in terms of jurisprudential development, particularly having regard to what the Supreme Court has stated in the past?
In novel areas where we don't have a local jurisprudence, such as that case we dealt with there. In addition to considering the context of Kenya as a country on a particular set of facts, the court has an obligation to be guided by precedents from jurisdictions all over. And I think they have done that consistently in their very, in fact, the many decisions of the Supreme Court, which I enjoy reading, very good decisions, and they do extensively quote from many jurisdictions. I think is a good thing to do, when you are dealing with tackling novel areas.
What is the caution that the Supreme Court has expressed even when you do that? It has always said something. It has always given a caution.
First of all, a judge doing that must be aware of the circumstances and the legal framework in which those foreign decisions were decided. Sometimes we may borrow precedents without understanding the legal framework and the context in which those cases were determined. So we must be careful as we do that to ensure, to make sure that we are dealing first maybe with similar circumstances, similar statutes, and all that, so that we do not misinterpret the foreign precedents.
The second case you dealt with was one of HIV and AIDS status, discrimination based on HIV and AIDS, and you've actually found that there was discrimination. This was a case of direct discrimination. Can you just tell us an instance where the discrimination would be indirect? Say HIV, a situation that would arise where discrimination would be indirect, or under what circumstances does indirect discrimination arise?
Indirect discrimination in many workplaces occur in disparity in terms and conditions of service in organizations where we have cadre from different racial backgrounds. So that you would, in some situations, find that a farm which originates from a particular place and therefore has been able to bring cadre from that where the company originated from will, within its structures, quietly remunerate equal staff quietly.
Isn't that that is actually direct discrimination? I'm talking about an issue where you have a neutral, the indirect is you have a neutral policy, but its effect is, so you don't know whether you have a neutral policy saying we shall give, we shall limit medical expenses to 10,000 shillings without being aware that you have people who are on retrovirals, isn't it? So you have an ostensibly neutral, so the effect is indirect. But back on your issue, and it's a case in which you dealt with, isn't it? The issue you have just spoken about.
Yeah.
You dealt with the this was the case of Cambridge, we know it.
Yeah.
You dealt with the trial case, and in the High Court you upheld. What did the Court of Appeal tell you? What did they say about your judgment?
I've actually not engaged with it because with that judgment of the Court of Appeal.
Okay.
I've not engaged with it yet.
Okay.
I'm very happy nowadays with the case back we are receiving from the from.
But
the
you
Court
know
of
that
Appeal.
the Court of Appeal dealt with it.
I did not receive case back from from it.
Do you know whether the Supreme Court dealt with your case?
The Cambridge.
Yes.
Oh, I would really love to
because
follow that.
There are very few cases that the Court of Appeal deals with. I mean, Supreme Court deals with. So that case is actually one of the ones they dealt with, and I'll tell you why.
Yes.
My colleague, Commissioner Orsame, he talked about the way you have. In that particular case, the Court of Appeal said, look, you failed to consider the evidence that Cambridge presented. That's what they said.
Yes.
They said you just took the plaintiff's case and never considered the other case, despite the fact that they had filed extensive documents. But maybe I will not pursue that because you have not read what the Court of Appeal and Supreme Court, that's what they said. They said, both of cases said you had failed to consider the both sides equally, which is a serious criticism, but nevertheless one that the court made. That brings me now to that issue. What is the difference between discrimination and differentiation?
Differentiation cases do arise in affirmative action situations where you could be doing the same thing but you're treated differently for lawful reasons. Discrimination is unlawful.
It's unlawful. It's on those prohibited grounds.
It's prohibited.
But this differentiation is discrimination that is justified.
It's justified and lawful.
And lawful.
Yes.
So in that case which you have were trying to mention, and not even that case, you have your company, let's say Kenya Railways, for example. They have engineers, grade X, job group M, earning 200,000 shillings a month. They want to invest in a system that changes the way in which the trains work. And none of the engineers qualify for that particular, they are all engineers. and they discover this gentleman engineer from Nigeria who doesn't have a degree, but he has invented a system which resolves that problem. And when they call him, they headhunt him actually, and they tell him, you know, we need you here because we want to invest in this thing. And he tells them, you know, I want you to pay me 800,000 shillings per month. And they bring him and they pay him here. The engineers complain that this is discrimination because we are on the same group, but you are paying him 800,000 because he's a foreigner. Is that discrimination?
Remuneration and terms of condition of service should always be based on a transparent policy. So and where that does not happen, it creates, first of all, a lot of discontent and suspicion. So, for starters, whatever differentiation you make, for it to be lawful, it should be open and transparent. Unfortunately, this is often not the case. And that is what brings the sort of cases we deal with, which sometimes may not be justified.
Okay.
Yes.
Again, I would urge you to read what the Court of Appeal said in the case which you decided. The other case is the Sonko case. And just probably explain, all of us know what employment is. And this is an issue that I don't know whether it has exercised your mind. I know it came from a Court of the Appeal decision. Sonko is an elected member of parliament, governor. But in terms of jurisdiction, forget about the Court of Appeal decision, is election as a governor an issue of employment?
Yeah, before I answer your question, let me say this. This almost 10 years since 2010, we are faced with that issue of forum shopping, constitutional division, employment and labor, different court users. Some file same case in both. Indeed, as you can see in that the history of that case, yes, was initially filed at the High Court, was transferred back to ELRC.
So tell us,
while I was in Kisumu, and by the time I dealt with it, it had been dealt with by 3 different judges for a whole year, and many decisions made, and the judges recusing themselves in the matter, and it was brought to me 2 days before the Senate proceedings by the principal judge exercising his powers, telling me that I know you are able to deal with this matter and deliver a judgment before the Senate proceedings. You can see that ruling. I delivered it in a record day, 1 day, after hearing very extensive submissions. And the issue of jurisdiction had already been determined by a different judge. So it was no longer open to me to entertain it. I'm very conscious of that. And after my decision, the petitioners have moved quietly back to the High Court.
No, so the issue I just wanted you to clarify for me in terms of as a principle, we know what employment means.
Yes.
So is the election of a governor an issue of employment and labor relations in your view?
In my view, elective positions, strictly speaking,
yes,
are not employment positions.
Okay.
But there was a difference. For example, like in the election of speakers, where before I made that judgment, there were preliminary objections on the jurisdiction of the court to handle.
No, that one.
Just a minute, and
yes,
that went to the Court of Appeal, and was decided by the Court of Appeal that we had jurisdiction.
Yes.
And that is how I dealt with it now.
No, you were bound by the decision of
the Court of
Appeal.
Appeal. So it's,
Yes.
it's
a problem area.
It's a problem area.
It's a problem area.
It's a problem area.
Let me move on to the one or two final issues before I wind up in my time. You have talked about, God willing, you'll be the Chief Justice, and one of the issues you'll be confronted with is the same issue you are talking about, management of complaints. And probably when you're the Chief Justice, there will be a new amendment to the Constitution saying that there's an ombudsperson, who will deal now with the complaints, not a parallel process for judges and magistrates dealing with with complaints. And for the public, the issue, unlike for us judges, they have said, in fact, the Judicial Service Commission is not doing enough to discipline judges. How, if that is the thing on your table, how would you deal with it? You will be faced with an ombudsperson appointed by the president. You will be sitting here as the JSC, and you will be addressing the judges and magistrates. Tell us briefly what you will be telling us and our judges that we need to deal with.
First of all the judiciary and independent institutions must be free from direction and control from anybody. And that is a constitutional edict we gave to ourselves. 2, all independent institutions must self-regulate and come up with viable self-regulation mechanisms, like we've done throughout the Judiciary Ombudsman and other mechanisms up to the JSC level, which we deal with public complaints. I have looked at the satisfaction report, the court user satisfaction report. The satisfaction levels.
No, the question I ask you is very clear.
Yes.
You have come in, constitutional amendment has passed, the first person on
has
the door.
Passed already.
No, I'm giving you a scenario.
Yes.
Because it is something you have to factor.
Sorry, I didn't get that.
We have no control over that process.
God forbid.
Yes.
Commissioner, let the judge answer the questions, please.
Yes.
I had not gotten the fact that it has passed.
No, I was giving you a scenario saying you come into the office. This was my question. You come into the office, you find the constitutional amendment has already passed, and the person knocking on your door is the ombudsperson.
Yes.
So what is, in light of the problems you have identified in the disciplinary process, what will you be telling the JSC and the judges and magistrates? That's what I wanted to know. Because you have to project forward and have a vision to deal with that. Just that's what I wanted.
I'll start from the point that the judiciary authority is delegated to us by the people. And what the people decide, for example, in passing a constitutional amendment like that, is a command to us as a judiciary. And if that will see the light of the day, my only obligation as a Chief Justice is to make sure that it is implemented in a most just and fair manner. And that will be my communication. And we will be able to work out the mechanism of dealing with the Ombudsman, who I believe will be a member of the JSC, and therefore if he's out there, he's still with us, and we will find a fair way of dealing with both sides.
Okay. Finally, and my final question, you talked about your defense of the Mutugi Bafo. You confirm, in fact, there were acts of torture of your clients, that in fact they were convicted based on that confession, and that finally the state conceded. Just tell us, how has that colored your perception of the work you intend to do as the Chief Justice? Thank you.
First of all, I do not take what Kenyans, the progress we've made by giving this constitution to ourselves in 2010, knowing and having experienced what many people went through in the 80s and 90s, having participated and actually experienced violation of dignity to the extreme of Kenyans, where confessions were extracted in very, very, very difficult environment with the complicit of the office of the Director of Public Prosecutions. We've come a long way. And with that in mind, I would never ever wish that for anyone and for Kenya, that would ever see that happen again to anyone. And that is a north which will give me impetus and focus to uphold justice for all.
Thank you very much, Commissioner Judge Majaja. I just to emphasize that, Honorable Judge, when we ask for a sample writing, we normally are interested to see your skills in writing judgment and not so much the merits and demerits, because that is discretion. I just wanted to let you know that we don't get into merits and demerits, because that borders on discretion. We normally look at the skills in writing those judgments, and sure. That's what Judge Majaja was looking at. Thank you.
Thank you.
Commissioner Ajero, can you go ahead and ask questions? Oh, yeah.
Now, Honorable Judge, I'll very briefly go again to the issues of jurisprudence. Then we come to, I'll try to match your skills with the job you are seeking. Now, the sample writings that you've been referred to, there's no doubt you write well. And I'd initially intended to ask you about those decisions, but my colleague has done a good job in that. Now, I'm interested in this case of Equare, because it seems to like it was groundbreaking. And there are two key areas, the one of discrimination based on the issue of HIV, and also the wage disparity. Now, just tell me so that I can understand, your reasoning and how you came about the decision. What exactly informed you, particularly on the issue of wage disparity? Because it's a common area amongst employers where you find that two people are being paid differently for the same job, and particularly women suffer more. The gender inequality when it comes into the women are paid, vis-a-vis men. I'm not sure what could have been the influencing factors to you as a judge in coming up with this groundbreaking decision.
First of all, Commissioner, thank you for that question. This area of discrimination, especially against women, is very well written and researched by ILO and these institutions, and they have promulgated conventions, declarations in that area, which guide courts, different nations, to deal with matters of discrimination. During my time, especially that time when I was writing that judgment, I had initiated interactions for training judges of E&LC, and got an ILO to directly train E&LC judges on awareness of discrimination, different sorts of discrimination. I myself, having been a judge president of Labor Court in Swaziland, I had vast experience in that area. It was my desire that all the judges of the court interact with it. Two, I'm very passionate about mothers and girls. It's a matter at my heart. And it is a fact all over the world that women are paid much, much less than their male counterparts for various reasons. And the key issue is the fact that they take time to go and give birth. They need days maternity leave out there. And the greatest area of debate and conflict at the ILO conventions is the period of maternity leave. Employers fight tooth and nail to limit maternity leave to 1 month and even less. In fact, that we have embraced 3 years of maternity leave in Kenya is a great progress for women in this country.
That you mean 3 months, not 3 years?
3 months, 3 months. So that is, that background I had, Judge,
Okay.
as I dealt with that matter.
Now, tell me, as a follow-up to that, how, if you became the president of the Supreme Court, of course now as a Chief Justice, how you would be able to use the law in ensuring that you're able to anchor, this development of jurisprudence to protect women, especially when it comes to wage disparity. How you would be able to progress it, that it becomes all-embracing.
As a Chief Justice, all I will do is to implement our Constitution. We have such a great Constitution. Article 2.5, Article 2.6, Article 10, Article 20, Article 159, Article 259. They have commanded us to develop the law using especially international instruments. It's sitting with my colleagues who I believe would have very amiable relationship with. I'm sure, and I regard them with very high esteem. We should be able to do groundbreaking development of the law in areas which impact our children, our mothers, our boy child, especially now completely under siege, and persons with disability, and deal with all forms of discrimination.
Yeah.
Yes.
Now, the reason why I'm asking this, my lord, is to see the nature of our patriarchal society, and you find that, the influences, the way we are brought up as men, sometimes will also influence how we project our decisions. Now, I'm just wondering, as the leader of the institution, if you could just explain very briefly how you would be able to also use your influence so that even as you're making decisions, these prejudiced influences that come from the way we were brought up in society don't project in the way we make the decisions that end up now continuing with these inequalities. How you would take that, because again, you accept this decisional independence on the part of judges, but how would you now use your influence positively to
First of all, thank you very much. The Kenyan judiciary has completely embraced training and education. Thanks to Chief Justice Mutunga JTF. And the greatest instrument I use as a Chief Justice, in addition to the collegiality, the key to unlocking that is awareness training, social context training. It's a big instrument in transitional nations, nations in transit from oppression to freedom. I had occasion to interact with the context awareness training a lot while I was in South Africa, where Canadians usually visited to train us in that area. And in particular, I remember very well Chief Justice Catherine Fraser of Alberta, Canada, who is a champion in context awareness training. And the doctrine that judges in their decision making choose values and not precedents. When you're dealing with high caliber judges like we have in the Supreme Court, you persuade them through training, exposing them to the correct, to peers from other jurisdictions, such as Chief Justice, I think Emeritus Catherine Fraser, who are so forceful in their rendition in these areas of law and context awareness training.
Yeah. Now, the other section of our society that has been discriminated against so much is transgenders. I don't know whether in your career you've been confronted with a situation whereby you've had to deal with a situation, with a case relating to discrimination against the transgenders, either in writing or hearing the case and how you've dealt with it.
I've not dealt with an actual case, but they have, what's the name of this organization? One of the organization in Kenya, human rights organization, has invited me severally in their training programs for LBGT, and I've had occasion to interact with them a lot and to give them to make presentations to them. And our court, the Employment and Labor Court, I think the organization is KELA, is it?
Okay.
Also, we attended many trainings during my time as a principal judge to sensitize us in those areas. Of course, we know what our constitutional position in those areas, and difficult areas as they are because of our constitutional edicts. But these societies evolve, and our constitutional dispensation in that area will definitely one day reckon with it.
Yeah.
But I have seen groundbreaking High Court decisions by some of our eminent judges dealing with the matter. And so I'm aware of it.
Okay. Now, coming to you as an individual, I must say that even when I was also much younger as a lawyer, I heard a lot about you in handling those cases that many other lawyers, we must accept or are frightened of, of handling them, defending, the likes of George Anyona, and the rest, and it's quite commendable. Now, I don't know if I could ask again. Of course, you touched on it, because I find you a lot of times as a defender of rights of individuals, which is a good thing, and again, as I say, I commend you for that. I don't know that those experiences have continued to influence your decision-making process, and also, of course, that also influenced your judicial philosophy, generally based on your personal experiences.
Yes, and to a great extent, but I'm also very balanced, given circumstances of the case. And that is why you can see I have a lot of experience in working for employers, local and international. I've served governments very faithfully in the Kingdom of Swaziland, here in Kenya, and at the EAC. I have really participated in developing key instruments for the East Africa community. So I have a sense of balance and of purpose, and to uphold the law in a purposeful manner. And so I have a balance, although I might accept that the context, the social context, is part of a judge's decision-making philosophy, impacts on the philosophy of the judge.
Yeah,
it's a fact.
Yeah. Now, Honorable Judge, I do not know now, what is your position regarding judicial overreach and judicial activism in development of jurisprudence?
In the context of Kenya after 2010, where we have specific articles in the Constitution, Article 20, Article 259, dictating to us to develop the law, and dictating to us the values and principles which are part and parcel of our law, and we must take them into consideration as we interpret our law, and getting constitutional edicts that we must interpret the law to fill in the gaps to the extent that they do not uphold effect our Bill of Rights. Failing to implement those edicts and dictates is what I would call activists. Because we have an edict to develop the law, and in terms of as guided by the Constitution. So if you as a judge are not guided by those edicts, then that's what I would call activism, but in the negative sense.
Yeah, okay. The reason I'm asking, because I've seen very good decisions that you've made, which I agree with, and largely, I see somebody who wants to protect the rights of, individuals. But again, I've also seen a situation whereby I think in arriving at a decision, you didn't consider the bigger picture, or where there was now judicial overreach. Not to criticize you, I'm just saying that when I look at the decision, and there's one case particularly that, because of course, even as we, prepare to interview candidates, you have to also do a bit of research to see the decision they've made. There's one decision that troubled me a little. The KNUT case versus the TSC. And in fact, when I look back, I remember that case was it captured the country because there was a strike and kids were affected, they were away and all that. But now, what I noted about that case, if I could just explain for just 1 minute, I noted that there was extensive evidence that was given in court where economists actually came and said that if you give the awards that the teachers were asking at the time, and we respect teachers and we want them to be paid well, of course, but if you give the awards that they were asking for, the implication would be so big in the sense that it would affect our wage bill in the country would end up being 95.3% right, of our domestic revenue, because it would create a very huge disparity where it would affect also all the other civil servants. That would mean that our taxes would have to be increased. You can imagine 95.3% of the wage, of the consumption just going to wages. Now, you are told that it would also affect the pension liability, which at that time was, I think, 998 billion shillings. That in itself, the government will not even be able to, the country will not be able to afford. In fact, to me, when I was looking at it, it would literally amount to a national security threat in terms of the implications of the decision. Now, but in spite of all the evidence that was submitted by all these economists, by these specialists, you still ignored all that and went ahead and gave 50 to 60% award, notwithstanding all these warnings about what it would have in terms of implication in the entire country. In fact, you're even told there was even no budget for it. It had not been budgeted for. So it would also disrupt the budgeting process. In fact, you are told, before now you can answer, that you are taking over the work of 5 other institutions. You're taking over the work of Salaries and Remuneration Commission, Teacher Service Commission, Controller of Budget, Parliament, and the National Treasury. You became a conciliator, went ahead, and so all those issues. So I was just wondering, if you became now the Chief Justice and you are not looking at the bigger picture, you are looking at the rights, yes, of one section of the society, but ignoring the bigger picture. I mean, how would that work, if I may ask?
I do appreciate your analysis of that, but there was also evidence from the other side, correct? From the workers, and the history since 1997 of denial, agreements reached, denial for years, salary negotiations agreed, given in installments in 5 years. So there was compelling evidence also from the workers, from the teachers of this country, who at that time were earning from 15,000 shillings a month, a majority of them not beyond 30,000, 40,000 bracket. So we had the evidence from the economists. We had counter evidence from the workers. We had reports from SRC. We had agreements at 50, 60%. During negotiations, I actually implemented what had been agreed upon, but reneged upon after SRC intervened. There was already an agreement at 50, 60% by parties, both parties. SRC stepped in and they reneged on that promise. That was the context of it. And as soon as my judgment was injuncted by the Court of Appeal, they engaged into negotiations, which have resulted in salary increments in the same line I had decreed. In fact, I believe still today, were it not for that decision, this is whether it was nullified after that, the situation of teachers would never have changed. Immediately before even the matter was over at the Court of Appeal, they had already started implementing. And it was implemented, and is a fact today, all teachers got between 50 to 60% salary increment thereafter. And there has never been a major strike by the teachers since then. And that was my focus. Because we had suffered, the children had suffered so much, the parents had suffered so much every day, every beginning of the year. there was a strike notice for a long period. So those are the facts which I took into consideration. I am not one to rock any boat. I've worked with governments for a long time. I've served the East Africa community for a long time. I'm very balanced. But I knew...
Actually, I don't have a problem with, taking decisions that are firm and all that. That's quite okay. I'm just trying to address the principles. It's so much about the principle, because when the matter went to the Court of Appeal, the Court of Appeal was of a different view. That's why I'm trying to follow that, because one, you became a conciliator, which the Court of Appeal was saying is against the Labor Relations Act. As a judge, you can't be a conciliator. Judicial overreach. The court said that you usurped jurisdiction you didn't have. You took over the work of other institutions. So basically faulting everything that you are saying that you did right. Now my worry is that you are taking a firm position that you are right in most of the decisions, even when the Court of Appeal is saying it's taking a diametrically opposed position to you. So would it then be a case of...
Can I correct you first?
Go ahead, my lord.
When the matter first went to the Court of Appeal, it was handled by a bench of none other than Commissioner sitting before Wasame as a judge of appeal.
Yeah.
In fact, at that interim stage, upheld the decision and directed that it be implemented. Another bench was constituted.
Five-judge bench.
To counter the decision by Justice Wasame's bench. So there's no, even at that level, there was no unanimity on that matter. So that is why I say that I may not have been right because I was corrected. One bench of the Court of Appeal and partly implemented that decision, overruled. Yeah. The government itself implemented the same, if not better terms as those. That is the reason why we got into some sort of court-annexed side mediation with agreement of the parties. What? Because there was already an agreement before court, signed by the parties, but nullified by SRC. That was the basis. That is what gave me, that was what was informing me that why did it, on balancing of the facts, that was a main consideration. That these parties had sat together for so many hours and days. They had hammered out an agreement. This agreement was about to start being implemented. And remember, there's a history of implementing these agreements in phases. That is what used to happen. They would agree on 50-60% basis. Yeah. Then they would then agree it will be paid in 4 years' time. So there was that history. And that is what was informing me. And I also had a lot of experience at Federation of Kenya Employers of hammering out CBA agreements. I have a great experience in this negotiating.
I agree with that.
It came from...
My worry, as I'm saying, is that you suddenly became now that conciliator who used to be at Federal Employers of Kenya.
Yeah, by agreement of the parties, and what I should have done, what happens in other jurisdictions, was after that conciliation failed, in hindsight, I should have handed over the file to another judge.
Absolutely.
It happens all the time in other jurisdictions. Judges can step in and conciliate, which is actually a very good thing if it is anchored in law. But as soon as parties decide that you can step in and bring them together, as soon as that agreement fails, then you pass the file to the next judge.
Right. And that's what now the five-judge bench, which...
in hindsight, that is what I should have done.
Chief Justice also participated in it, all observed. Anyway, that's okay, at least you accept that position. Now, my position is that, which is now leading to my next question, as the Chief Justice, what assurance would you give this commission and of course Kenya, because they're also watching, that if you made you the Chief Justice, that you'll be able to make decisions that always look at the bigger picture, because at the end of the day, it's a huge, huge position. It's not a small, you are heading the arm of government, where every single decision you make has national security implications. Not just on labor issues now, because now you are basically dealing with labor issues, but now you'll be dealing with bigger issues, where one single mistake could cost lives. It could cost, loss of jobs. It could cost, it can either make or break. You could make a decision that could either make, or you could make one that could break. So I do not know how what assurance you would be able to give us, so that as we retreat to decide with the Chief Justice, that notwithstanding other personal influences, I suspect probably the fact that your mother was a teacher could also have influenced you. I'm also influenced a lot by what happened to my mother as I grew up. We are all prejudiced, but you'll be the Chief Justice. I don't seek to be a Chief Justice. So I don't know how much assurance you'll be able to give, how you'd carry out your duties to ensure that you make a decision that look at the bigger picture at any given time.
First of all, our Constitution has got a lot of safeguards against impunity. There is no place for a dictator in our structure. Much more in the setup of the Supreme Court. There is no way a Chief Justice can have his way if it be unreasonable in that context. There's no room for a Chief Justice to stand there and pontificate unconstitutional and unlawful endings. Two, right from the university when I was gotten to steer, to bring peace within the very turmoil, difficult situations. And I was able to anchor the university through a very difficult period. And all the students from corners of Kenya trusted me to do that as a very young man. And I did, without a single strike, without a single student being expelled, not even a disciplinary hearing, until when I left. And as soon as I went to School of Law, before 3 months were over, we had another one of the most violent riots as soon as the next chairman was elected.
Yeah. Okay, now.
So, I am very safe hands. I have balance. I have a lot of balance. And those who have worked with me, especially at the East Africa community, including Justice Kehara, the Attorney General, who was my chairman of the East Africa Judicial Education Committee, where I developed many concepts to train judges in East Africa. And I actually delivered many trainings in all the 5 East African countries, raising funds, developing proposals and concepts, getting funds from development partners, initiating training programs here in Kenya, Uganda, Tanzania, Rwanda. Justice Kehara as my chairman, representing the nation of Kenya. I have a lot of commitment in what I do. I have a lot of patriotism beyond, and that is why I had to come back, even when I had very good position down there in Swaziland.
I thank you for that, my
Absolutely.
Lord. I thank you for that. Now, you
and
mentioned...
lastly, one which I forgot to mention in my CV, which you have, is that in 2010, when the referendum process leading to the promulgation of the Constitution was challenged in the interim constitutional court by organizations which felt that that process which birthed our Constitution was not fair and just, and they lost their case at the interim constitutional court, they filed a reference to the East African community. They filed against the Attorney General of Kenya and against the Secretary General of East Africa community, saying that the process which led to the promulgation of our Constitution and violated not only the laws of Kenya and also violated the East Africa Treaty. I was again called upon to lead the defense of this country in that case, which is in the first page of the East Africa Law Report.
Yeah.
You've seen it?
Yeah.
I led that defense of this country.
Yeah. My Lord, you are serious impressive.
And we succeeded to defend the detractors of the promulgation of our constitution.
I don't doubt your CV. It cuts across. I mean, it's really, you are widely exposed. That I have no doubt. Now, you mentioned something about the process of disciplining magistrates not being very clear. It's not, if it's there, it's not, I think I'm just quoting your words. You said that if it's not there, you're not familiar with it. But I thought it's quite comprehensive under Schedule 3 of the Judicial Service Act, because it's very comprehensive about all the steps. Maybe application is not being applied correctly, but in terms of the steps, I'm not sure whether you are aware about it, just as a matter of clarification.
During when I dealt with the case Commissioner Judge was dealing with, I interacted extensively with those schedules before determining that case, and I'm aware of it. Yet, there's so much disaffection in the cadre in the manner they are handled.
Yes,
especially in terms of timelines within which you were suspended on half pay, sometimes without pay. It takes many months for you, sometimes even years. I had a colleague in Kisumu who I think had waited for 3 years.
Yeah, I appreciate maybe
for our case to be determined without salary.
Yeah, maybe it's not being applied expeditiously. The implementation, there could be a problem, but it's not that there is no.
It's not
process.
What I'm talking about. I would want to do is to have the same way you have some simple documents developed and given to people with very precise and detailed of the expectations and steps to be taken and timelines.
Yeah.
That if should a magistrate be suspended pending investigation, blah blah blah, this must be done this way within this timeline, and should it not happen, this should happen, this should happen. In other words, I'm not looking for another regulation. I want to champion development of documents, simple documents with the people to be with us internally, to understand those processes, and so that if they are violated, we can say that why is a magistrate waiting for 3 years without pay?
I agree with you. I agree with
without
you.
pay.
On that. Yeah, we agree with you. Now, the final point on that, I also had you mention that you talked about if you became the Chief Justice, you emphasize so much on the judges and the magistrates, but I didn't hear you talk about the support staff, who are a critical component that is normally ignored. And sometimes I get the impression that even as judges and magistrates are talking about themselves, they don't seem to appreciate that these enablers, the support staff, are important because their work will also determine how effective the judges and magistrates, will be able to do their work. I would also like to hear a bit, about that.
Yeah, thank you very much for that. Was an omission on my part, and actually prepared myself on it because I'm very passionate about every staff member. I'm aware of the directorates and the staff who serve below them at the lowest level, and I also looked at their levels of satisfaction in the report, which were not bad. The percentages in that cadre of disaffection, some were very high, of satisfaction were very high. And that's why I did not become very concerned, because if I'm to be guided by that report, if it speaks the truth, it appeared to me like there was a very high level of satisfaction within the administrative cadre. And but it's an area I should be able to interrogate and to follow upon, because I believe that if all the staff, or any of the staff, they are disgruntled. Their issues are not being handled, especially the sanctions and the rewards. Another area I would want to talk about, for example, who knows what criteria is used for staff in the judiciary to be given national honors? Who knows which committee and who deals with it? I know there is one, but do we know? Do we know why some people have received 2 commendations from the president and others don't have one within very short timelines? Is it that the others are not deserving? Who deals with it? What is the criteria? Can we have a small booklet of 2 pages telling us this is a criteria of receiving state commendation as a judicial officer, as a magistrate, as a staff for the work you have done? These are the areas of disaffection where people quietly, because judges have no room to go out there and make noise. But it doesn't mean that they don't feel it. They're not they don't feel it. They can see, and they don't know why this, not why that. But so what I advocate for is a transparent edicts, little procedures, transparent saying, this number of judicial officers have been honored by our president, and this is a criteria which has been used, and in the future, this is the path we are going to follow for that purpose.
All right. Thank you, my lord. I wish you well. That's all for me.
Thank you.
Thank you. Thank you, Commissioner Jero. Your Honor, we will take a short break.
Appreciate it.
5 minutes. We'll come back, Honorable Commissioners, at 12:15. It's about 10 minutes. Thank you.